Well, it finally feels like Pride Month. Welcome, everyone. I'm Valerie Plumpus, the National Policy Director at Equality California. Our Power Hour discussion tonight will be focused on this morning's Supreme Court decisions in a trio of workplace discrimination cases. Two of the cases dealt with sexual orientation, Bostock versus Clayton County, Georgia, and Altitude Express versus Garda. The third case dealt with gender identity, Harris Funeral Homes versus EEOC. So I'm thrilled tonight that we have four legal experts who will be joining us to discuss these key Title VII cases. Rick Chavez-Zabur, the Executive Director of Equality California, Jenny Pizer, Law and Policy Director of Lambda Legal, David Cruz, Professor of Constitutional Law at the University of Southern California, and we'll be joined very soon by Shannon Mittner, Legal Director for the National Center for Lesbian Rights. So our collective joy in today's ruling is tempered, of course, by the backdrop of COVID, which has claimed the lives of so many people of color and nationwide demonstrations against systemic racism and anti-Black violence. And I'd like us to pause for a moment to reflect that of the three courageous people who fought back who were fired simply because they were LGBTQ, Amy Stevens and Donald Zarda, they both died before justice was declared in their names. We honor their memories and we thank their families for continuing the fight on behalf of their millions of people who have been affected today. So turning now to our distinguished panel, I'd love to hear each of you give a couple of minutes to discuss your biggest takeaway about today's ruling. Rick, could we turn to you first?
Sure. So first, I want to thank you, Valerie, for moderating, but I also want to thank some really amazing people who are joining us today. We consider Lambda Legal and National Center for Lesbian Rights and ACLU our community's law firms. This victory today has been the result of literally decades of work, really looking at how to make sure that cases are filed to build the case law that led to this decision, much as all three of those organizations did, leading to our victory on marriage equality in 2014. We at Equality California, really our role is that we are the legislative lead in California, really advancing LGBTQ civil rights and social justice laws. But even in that context, we work closely with all three of these organizations who provide the legal help that we need to shape those laws. And so I just want to thank all three of the organizations and want to thank Professor Cruz, who also serves on our board and really provides a lot of that kind of insight that we need as we shape our work. So I'm not going to say too much more other than what an amazing day. This is really a landmark decision. The Supreme Court has ruled that companies don't have the right to discriminate against LGBTQ people in the workplace. This historic decision says that LGBTQ people are and should be protected from discrimination under federal sex discrimination laws. And so while it extends only to employment, the case is going to be important in advancing our rights in other areas of federal law. And we know that ACLU and Lambda and NCLR are going to be using this, not only to help shape the strategy to achieve full lived equality for all LGBTQ people, but also using really this case to really advance LGBTQ civil rights, even in the states, because it really is important. I mean, just last week, the Trump administration tried to take away the right of transgender people to receive health care by taking away health care protections for transgender people under federal law, reversing what the Obama administration position had been, and really what our community has been advocating for many, many years, that basically non-discrimination based on sex extends to protect LGBTQ people because it is so intrinsically intertwined with who we are. So with that, I just want to thank you all for joining us today and really want to thank our distinguished panelists. All three of them are really incredible partners and incredible friends and do so much. They've dedicated their lives and their career to really advancing the interests of our community. And I guess the last thing I'm going to say is, this is a bittersweet victory given what our broader community has, the broader community and Black people in particular have been experiencing for decades, but really given the events of the last 3 weeks. We know, our mission at Equality California is to bring the voices of LGBTQ people to institutions of power with the goal of creating a world that's healthy, just, and fully equal for all, and all is a key word, all LGBTQ plus people. We know that part of that, as you focus on the words, bringing our voices to institutions of power, we know, and I think what has been underscored by the last 3 weeks is that we have a lot of work to do to really change our institutions, to make sure our institutions are treating all people fairly, to really root out of our institutions not only LGBTQ animus and discrimination, but really the racism that's embedded institutions related to the treatment of Black people, people of color, people living with HIV, immigrants. And so that's a core part of our mission. We approach our work with an intersectional lens, but we really, I think, know that we really have to lift up and rededicate ourselves to really combating racism and institutional racism and reforming our criminal justice system and making that a reinvigorated part of our mission. So with that, thank you for joining us today. Really happy to have you, and really want to thank our panelists.
Rick, thank you so much. So Jenny, if I could turn to you, what stood out to you today in today's ruling?
Well, this is a wonderful opportunity to be all together and have a moment of something to celebrate. As Rick said, we have been dealing with some really big challenges as a country, and we have seen a parade of really frightening confirmations to the federal bench, thanks to the Trump administration and the Senate. So I think quite a few people were surprised that this decision today was written by Justice Gorsuch, who was a Trump nominee, and joined by Chief Justice Roberts, I think is very well known as being a quite conservative jurist. So a chief takeaway here, I would say, is persistence pays. As Rick was indicating, Lambda Legal, the ACLU, National Center for Lesbian Rights, and many other determined advocates have been making these straightforward arguments about the words of the Title VII law, the federal employment law, for a very long time. And for many years, we faced arguments like some of the arguments rejected in the dissenting opinions today. And then we started to have wins, and they built to the point where the logic we'd been laying out was accepted by the majority today. So persistence pays off. That's number one. Reading the law and calling the courts to apply the words on the page without writing exceptions into the law just because they think, well, Congress couldn't have meant that. Well, they used the words they used, read the words and follow the words. And that's the decision we got today. It will have huge implications for other areas where we currently have federal non-discrimination laws that also prohibit discrimination because of sex. The decision today applies to employment discrimination, but the reasoning, the understanding of what the words because of sex mean, and the conclusion that there's no way to understand different people, different treatment of LGBT people, no way to understand that other than a different treatment because of sex. That's going to have implications, as we will discuss this evening, for healthcare and education, access to credit, housing, a number of really important areas. So it's quite huge. Two other quick takeaways. One is, boy, it's pretty clear that the dissenters don't seem to like LGBT people very much and are willing to twist their legal arguments around in knots to come up with reasons to say no. So that's not a surprise, but that's troubling. And then the last thing, which we will discuss more, I'm sure, is the conclusion of the majority opinion, in which Justice Gorsuch talks about his concern about religion and people who are motivated to discriminate because of their religious views, and the potential to be decided in other cases that there may be exceptions or accommodations or reasons that non-discrimination laws might not apply because of religion. Lots of contexts and multiple cases addressing those issues, They were not before the court in the cases decided today. Those are things that we all are going to need to work on. And I guess I'll say as a concluding thought, and Rick was indicating this, there have been protections against race discrimination and discrimination based on religion and national origin and other grounds. And there have been laws against racist police violence. And there have been other laws on the books for a long time. And that does not mean that those practices don't happen. So as we have the legal protections, which are essential, we also need enforcement, and we also need to change the conditions and social understanding so that people know the laws are there and they follow those laws so the bad, harmful conduct doesn't happen. So today we celebrate, but we still have a lot of work ahead.
So well said. So David, you're a constitutional lawyer. What stood out to you today?
A lot of things. I would not disagree with anything that Jenny has just said about this really momentous decision, capping decades of work, initially by individual LGBT people pressing their claims for justice under the law, and then picked up by the wonderful organizations that Rick talked about. I think that what we saw today was a circumstance in which we have made enough progress in the culture that judges were able to reject the idea that, well, of course, there has to be an exception here. What Justice Gorsuch's majority opinion referred to as there's no donut hole principle that would carve an unspoken middle out of some general principle, even though the statute doesn't indicate that. But it's impressive that we secured not just the bare majority, but 6 members of the court, the 4 more liberal justices and 2 of the more conservative justices, to deliver this interpretation of federal law, in part because the sex discrimination argument has been pressed before the court before. Chief Justice Roberts himself raised it in the marriage equality oral arguments, only to reject the plaintiff's claims there under the Equal Protection Clause without speaking of it. He just dealt with the due process claim. So that was a notable case where he, perhaps given the strength of his reaction to the facts of that case, didn't engage in careful legal analysis. We saw that going on in the majority opinion today. And so the big question really is going to be, are people going to take seriously what the court ruled, what its logic is, which, as Jenny said, is going to have lots of potential implications for other federal laws. I am hoping that Justice Alito, in his vituperative dissent, will prove as prophetic as Justice Scalia in his dissents in cases like Romer versus Evans and Lawrence versus Texas, which accurately anticipated the pro-LGBT development of constitutional law. I think the decision also is likely to have ramifications for constitutional law. Again, one of the things that Justice Alito frets about in his dissent, but this understanding that you cannot discriminate on the basis of traits defined in terms of sex, like sexual orientation or transgender status, without discriminating based on sex, is likely to put pressure to encourage the lower courts to say, yes, we should have heightened scrutiny, less deference to the government when it discriminates on these grounds, and when that's challenged under the Constitution's guarantees of equal protection. And that will be very salutary. While there's wiggle room, I am encouraged by so much of the court's reasoning today.
Thank you so much. So I'm delighted that Shannon Mittner has just joined us. He's with the National Center for Lesbian Rights. So Shannon, we've just been talking a little bit about our main takeaways from today's ruling. So everyone else has spoken. Maybe you could tell us what really stood out to you today.
Oh my gosh. Well, I am still in a very good kind of shock and awe at the decision today. It was so powerful. I'm delighted that we got not only Justice Gorsuch, but also Chief Justice Roberts, 2 of the most conservative justices on the court. Honestly, as I've been saying all day, this decision is about as near perfect as I could imagine it being. It's so clear. It's so straightforward. There's no equivocation. There's no obvious loopholes. They're like, yeah, discrimination because a person is lesbian, gay, bisexual, or transgender, that is sex discrimination, plain and simple. The other thing that just I thought was so amazing and just spoke like in a very like understated but incredibly powerful way was that one paragraph where the court talked about Amy Stevens. They didn't say a lot about the plaintiffs. This was not like an old style Justice Kennedy opinion with a lot of kind of emotionality and flowery language. But that paragraph about Amy Stevens, it evinced so much empathy and compassion for her as a transgender person. And it was so unequivocal and unqualified in referring to her as who she is, a woman, transgender woman, that I was like, oh, thank you, court, for doing that. I think they sent I think that was a very intentional, very pointed message to all of us, but also to the lower federal courts. And I'll just say, including the handful of some recently appointed Trump-appointed judges who have been very disrespectful to transgender litigants. So I was so happy about the power of the whole decision, but that paragraph in particular.
Excellent. Thank you so much. If you're just joining us now, welcome to Equality California's Power Hour discussion. We're talking about today's Supreme Court cases and the 3 Title VII cases. So if you have any questions, you can post them for our expert panelists in the Q&A box in the lower part of your screen. So if I could just turn to the entire panel, these questions are for anyone. You can discuss and pick up each one. So with today's big win, do we still need the Equality Act? I don't know, Jenny, maybe you want to take that and kick us off.
I will be happy to kick it off as somebody who is really delighted and excited to participate in the careful group process of drafting that law a number of years ago. And it's been it was introduced a number of times, and it is now, a year ago now, was passed by the House and is now in the Senate. And absolutely, yes, we do still need the Equality Act. Today's decision is incredibly important. And as I said, and I'm sure we'll discuss more, it does have these powerful analytical implications for discrimination in these other areas that also are covered by federal sex discrimination laws. What the Equality Act will do is it essentially takes today's decision and writes it into the statute so that no matter where people look, whether they look in the case law books or if they look in the statute books, they'll see, oh, no question, yes, this is covered. But it also adds protection against sex discrimination understood to include discrimination based on sexual orientation or gender identity, and some other sex-based types of discrimination as well, related, for example, to pregnancy. That protection is added into the federal law about public accommodations, which is sort of a legal term that covers businesses, forms of transportation, or goods or services offered generally to the public. Currently, that federal law is somewhat narrow, and it does not include protection against sex discrimination. So the Equality Act changes that, adds sex discrimination protection, incredibly important for LGBTQ plus people and for women and anybody else who would be subject to sex discrimination. And it adds that same protection to the part of federal law that prohibits discrimination in programs receiving federal funding, that's many programs and many services, medical, for example, and many other areas of goods and services. And lastly, it expands the protection in federal law of the public accommodations statute to cover lots of things that were not recognized as so important when the law was first passed back in the mid-60s. Transportation services, ride shares, various kinds of business, financial services, and of course, retail. So it does lots of things that we all need and that many people have been assuming for a long time were part of federal law, but they weren't, and they should be. And so we need the Senate to take up that bill and pass it, and then we need to have folks in the White House who will be happy to receive it and make it federal law.
Exactly. Well, I see the three of you all nodding your head. If anyone else want to talk about the Equality Act?
I think I agree with Jenny, as I always do, that we still need the Equality Act.
That's great. So does that mean that really LGBT workers are all set with this case? I mean, there's nothing else for us to worry about?
Unfortunately, not even close. And part of the problem might have particular weight for some of our poorer community members, because there are limits to Title VII of the Civil Rights Act that the court was ruling on today. The employers that are covered are not anyone who employs someone. There are size requirements for private employers. You need to have at least 15 employees. There are a lot of small businesses in the United States. And if you are an economically dependent worker employed by one of these, you do not get any of these protections from Title VII. You don't get the race discrimination protections, which again gives us another way in which members of multiple marginalized communities, due to the intersectionality of our identities, may be facing a lot more vulnerability than we realize. This is a tremendous development. It cements protections across the entire country, including the majority of states that don't expressly prohibit sexual orientation and gender identity discrimination in their employment laws. But it has limits to its reach, and those are something that we absolutely need to press on and expand further.
Thank you. We have a question from Tracy, and I think that's directed to Shannon. Does this mean that they won't be able to discriminate against LGBTQ plus people in healthcare? Maybe you can talk a little bit about the Section 1557 in the Affordable Care Act.
Yeah, well, I'll give it a shot. Yeah, I think it's been noted a few times now. There's nothing in the court's analysis today that would be limited to Title VII. You know, Title VII prohibits sex discrimination in employment, but the Affordable Care Act prohibits sex discrimination in healthcare. And there's no reason that the court that I can tell from anything about their reasoning and the decision today that would not apply equally strongly to the sex discrimination provision of the Affordable Care Act. So I am incredibly optimistic that we are going to see lower federal courts, hopefully, and if and when it reaches the Supreme Court again say, yes, LGBTQ people are protected under the Affordable Care Act. And so this decision today too, and that way, it just was like such a direct rebuke to everything that the Trump administration said to defend the horrible rule that it promulgated last week, where it tried to take away all protections, particularly for transgender people, but for all LGBTQ people under the Affordable Care Act. The administration, when they did that, they promulgated this like really long, like 72-page legal memo that went on and on and on about all the reasons why discrimination against a transgender person is not sex discrimination. And the Supreme Court, with today's ruling, just knocked that right out of the water. I mean, they just, I'm not suggesting they were directly responding to that analysis. I'm sure their decision was already written before it came out. But if you put the two side by side, the decision today just totally rejects everything in that Trump memo. So I'm really hopeful we're going to maintain and secure our protections under the Affordable Health Act.
Well, that's fantastic. We have a question from Zero. Since the decision specifically referenced trans people being fired because their gender identity doesn't match their sex assigned at birth, does that mean that someone whose identity does not have a sex correlation, i.e. non-binary people, are not protected? I don't know who wants to take that.
I mean, I wouldn't
Jenny?
think so.
Sure.
I mean, it's basically whether you're binary, it still relates to whether you identify with one gender or another. So it still is related to sex. So I would argue that it would extend protections. I don't know, David, Jenny, or Shannon, whether you would disagree with that.
Well, yeah, no, the court's reasoning talks about sex-based rules, sex-based considerations, sex as a factor, sex is inextricably intertwined with a person's gender identity. A gender identity is, it seems, necessarily related to sex. And its logic then would seem to extend that. And again, this shouldn't come as a surprise to any of the 6 majority justices, because Justice Alito flags that as one of the potential consequences of the decision. So when we talk about how broad the logic and the ramifications of this are, this is not something that is surprising. It is something that is completely apparent to the majority. And that gives me some encouragement that we won't see people peeling off when additional challenges eventually get their way to the Supreme Court. And very, very optimistic, as Shannon was, about the prospects in the lower courts now on all of these other fronts about what sex discrimination protections mean.
Thank you.
What I would add to that, I agree with all of that. The analysis that was used systematically rejected the same kinds of arguments that we would expect to be made by whether it would be the Trump administration or somebody else in the future, to try to say, but that discrimination is different, or that context is different. If we anticipate, based on everything we've been seeing for years, the kind of arguments that would be made, most of them have been considered and dispatched in the majority opinion. I think many of us will be publicly calling on the Trump administration to withdraw, for example, the offensive and outrageous rules that were issued late on Friday about healthcare, and some of the other rules and guidance and statements that have been issued because they fly in the face of what the Supreme Court just said. The administration may or may not do that, but I think in particular, employers, landlords, and government employees who continue to discriminate in the face of this decision should take seriously that they may well have serious liability on their hands. But the fact is, the court just decided the cases that were in front of it today, but the reasoning is out there. And that's part of what we all are doing in our work and in our roles within the LGBTQ movement, to expand the education. I mean, it's an important part of what Equality California does, because we need everybody to know. We need workers and tenants and patients to know. We need the people who are providing services to know that this is how we should be understanding the law. This is how the Supreme Court is understanding the law, so that if discrimination continues, then it's that much more likely that there would be liability. And it's not as if everybody can get a lawyer and can bring a lawsuit. And heaven knows, all of us who are lawyers know that litigating cases is not exactly fun, and it's not fast, and it can be expensive. So this is not like, yay, everybody's going to get to have a lawsuit. It's more that the message is really powerful, that this type of discrimination is sex discrimination, and there are important laws already on the books, and they need to be understood and followed.
Thank you, Jenny. So this next question has to do with religious freedom. Can you comment on how this ruling will apply to those sorts of cases?
Well, I'm always happy to talk about that. I know it's also one of Professor Cruz's favorite areas, and Shannon's pretty steeped in it as well. So we probably all have something to say about it. The starting place is that Justice Gorsuch, at the end of the majority opinion, flagged that there are issues about religious freedom that crop up in some of these contexts, and that the court was not considering them or deciding any of them in this case. And in fact, one of the cases, Amy Stevens' case, did have a religion defense earlier in the case, and the Federal Court of Appeals considered it and rejected it. And the lawyers representing the employer in that case decided not to present those religion arguments to the Supreme Court. So they were in the case, but they didn't make it to the Supreme Court, and they weren't decided. I think the bottom line is that as it is now, the federal civil rights statutes do take account of religious freedom issues and do give a structure for how religious freedom rights coexist with rights against discrimination. And in our view, that does not really need to be changed. It just needs to be applied more consistently now that it's clear that LGBTQ plus people are covered by the federal civil rights law.
Yeah, I thought it was very interesting that the court made a point of observing that the religious freedom claim under the federal statute, the Religious Freedom Restoration Act, was dropped from this case. And it gave me a little bit of not perverse, but a little bit of glee, because the attorney for the employer in Amy Stevens' case is a Christian right legal advocacy group that is very well funded and is engaged in a great deal of litigation against the interests of the LGBTQ plus community. And they went for broke here. Rather than present the court with their religious freedom claim, which I think the lower court did correctly reject, but which would have faced a receptive audience among some of the justices of the Supreme Court, they were trying to get it so that no employers were covered by the Federal Civil Rights Act when it came to sexual orientation and gender identity discrimination. They wanted a sweeping victory saying, sorry, none of you are protected as a matter of federal law. And so that was the only question they gave the court. That was the question the court took up, and the court ruled against them resoundingly.
Yeah, those are such good points. And then David, I totally agree, and it's kind of an interesting how that worked out. Just to break this down to make it really simple, which is helpful to me and maybe helpful to other people out there. As David just noted, the decision today in Jenny 2, this decision today did not raise any religious exemption claims at all. So as far as today's decision goes, it doesn't tell us anything about how the court might respond to an argument from a religious employer saying, okay, well, we understand that Title VII protects LGBTQ people, but that infringes upon or burdens my religious freedom in a particular case. And that it's going to be really important to see how the court does respond to those kind of claims going forward. And there was one paragraph in the decision today where the court's like, look, we know there's a lot of people out there who are worried about how Title VII is going to interact with religious employers, or how it's going to interact with constitutionally based religious freedom claims, or even the statutory ones under this federal law called the Religious Freedom Restoration Act. And that's going to be really important. And there's reason to be somewhat, I don't know, concern might be too strong of a word, but it's something we need to keep an eye on to see how this court grapples with those issues. And they very well may issue some decisions, even in the very near future, that give us a little more information about whether we need to be concerned about undermining anti-discrimination protections for our community through religious exemptions, and if so, how concerned we need to be.
One of the things I was surprised about. Okay. One of the things I was surprised about was the where Justice Gorsuch came out and really sort of the rejection of the originalism arguments that Justice Kavanaugh embraced, and which has been a part of the conservative wing of the court for so many years. I'm just curious whether Shannon, Jenny, and Professor Cruz, whether you were surprised by where that came out. It seems like this was good news, and that these arguments that you actually had to think about what the framers intended, or what the legislature might have intended at the time a law or constitutional protection was adopted, was something that was rejected today. Really looking at sort of a textual reading of the Constitution. I was just curious of whether you were surprised by that.
Pleased, not super surprised, at least with Justice Gorsuch's analysis, given some of the approach that we saw him taking during the oral arguments in the fall. To us, it was quite straightforward, applying one of the decisions written quite a few years ago by Justice Scalia, former justice, no longer living, who was among the most conservative in some ways, and one of the main proponents of a textualist approach. his view, which was applied today, was look at the words. What do they mean? Just apply them. Don't consider what somebody may or may have been thinking when they were in Congress at the time. And sort of don't add things to the statute if the words are plain and you can just apply them. And that is exactly what Justice Gorsuch did. And it was somewhat not funny, but it's peculiar then to see Justice Alito using the language of textualism to say that you should be considering legislative intent. Like, oh, well, nobody thought this would happen. Well, they used the words that they used, and that's exactly what Justice Scalia said you're supposed to do.
David, I don't know, or sorry, Professor Cruz, I've known you too long. I bet you have thoughts on this too, but I just kind of for a moment from like the human interest angle of all this, yeah, it's really astonishing. I mean, Justice Gorsuch was like the main thing that President Trump, one of the main things he's been so proud of, you know, getting this conservative justice on the court. And there's a lot of conservative commentators and lawyers out there who have said, yes, Trump's terrible, but Gorsuch, you know, but it was worth it because we got this amazing, like the archetypical conservative, classic conservative justice on the court. And I think today's decision was very shocking to a lot of those people, like really shocking, because many of them, I think it's safe to say the vast majority of them do not think that Title VII protects LGBTQ people and are very upset that their conservative justice actually wrote the opinion saying that our community is protected under that law. It really is stunning, and I guess we just have to acknowledge it is a testament to his integrity, Justice Gorsuch's integrity as a judge, that he really, you know, it must have been very hard for him. I just think we should acknowledge it must have been very hard for him to write the opinion that he wrote today. And he knows that he has disappointed and angered a lot of the people that expended a lot of their personal and political capital to get him on that court. It was also interesting to see how President Trump responded to that today, not to take us in a political direction, but it really put Trump, I think, in a very difficult position because he's the one who picked Gorsuch to sit on the court. So if he was going to lambaste this decision, well, who's to blame? He's the guy that put Gorsuch there. So I think the politics of this are all very intense and really interesting.
Trump judges, as the president might refer to them. But you're right. I think we simultaneously should not lose sight of the fact of why Justice Gorsuch occupies his seat on the Supreme Court, because the Senate Republicans acted contra-constitutionally and would not even provide a hearing to President Obama's nominee. I am relieved and somewhat consoled that Justice Gorsuch is, at least in some cases, able to bring himself to follow the law and logic and not graft a queer exception onto his legal reasoning, as has happened too many times in the history of these movements, of which we're all a part, as all of you can well testify. The idea that ordinary legal principles might not apply, which we can see when we look at some of the contortions Justice Alito goes through in his dissent to deny that there's sex discrimination when an employer who fires someone who's married to a man will fire their employee if it's a man married to a man, but not when it's a woman. How he thinks that that doesn't depend on the sex of them, that isn't discrimination, is almost literally incomprehensible. But I agree, this was an example of following law and logic, and it's one that is going to have a concrete applicable legal effect as well as a symbolic effect, and be influential in lots of litigation and advocacy. And it may also influence state laws. Pretty much all of the states have a lot of laws that prohibit sex discrimination. And we've started to see, even in the South, some of them acknowledging the force and accepting that when you discriminate based on sexual orientation or gender identity, you do necessarily discriminate based on sex. I think the Supreme Court's sort of not bipartisan, but bi-ideological agreement with that principle is going to lend some momentum to those kinds of decisions. And I would be remiss to not note while we're here, and I just mentioned bi-ideological, that once again, we do not see the justices grappling explicitly with the fact that there are bisexual people, that there are many bisexual people, that they are protected by this. And we need, I think, instead to take some comfort, non-trivial, in the fact that the court's reasoning, I think, when you read it, says, yes, you're protected under Title VII too. That is still sexual orientation discrimination. And the court is very clear about having discrimination against sort of two groups doesn't cancel out. And I think that will be of great use if anyone does make the expected arguments about why we shouldn't think that these statutes protect bisexual people from discrimination.
Very interesting. Rick, if I could pivot to you a little bit. So many of the partner organizations on this panel, and of course many others, including the ACLU, as you mentioned in your opening statement, have worked for decades to move the needle on public opinion. So obviously our collective efforts are working. I think a CBS poll found this month that 82% of Americans, including notably 71% of Republicans, said the Supreme Court should extend the civil rights protections to lesbian and gay people. What would you say are the other areas of work that we did in California, maybe the rest of the country, to bring about full equality?
Well, we know that the laws are important and they're fundamental, and I think that one of the things we do is to pass laws and to fill the gaps in the civil rights protections that we have here in California. But we also know that we need more than civil rights protections. If you actually look at the health and well-being of LGBTQ people in California and across the country, we know that even here in California, where we've got strong LGBTQ plus civil rights protections, that we actually don't have lived equality. If you look at almost every measure of health and well-being that the LGBTQ people that measure our lives, everything from rates of homelessness, where 4 out of 10 homeless youth are members of the LGBTQ community, similar numbers for LGBTQ plus adults, high rates of poverty, high rates of low rates of school success, high rates of interaction with the criminal justice system, high rates of conviction upon arrest, low rates of healthcare coverage, high rates of smoking. Really almost every measure, LGBTQ people fare poorly. And if you're a woman, or if you're a member of a community of color, or if you're an immigrant, or if you're a person living with HIV, you're at the very bottom of every measure. And so we know that in order to achieve full lived equality, it's a combination of doing more to really change the institutions that help LGBTQ people, that help members of the general public when they're facing challenges and crises in their lives. If you think about it, what does a member of the public generally do when they are facing a challenge? They might go to their student, they might go to their teacher or their school guidance counselor. You might go to your healthcare provider. You might go to your faith community. You might even go, in some cases, to law enforcement. Every single one of those institutions, at best, lacks an understanding about how to provide services in a way that's safe and supportive of LGBTQ people, and in some cases, and as we're seeing, are outright hostile. We see that in particular in the Black community and among members of communities of color, and then if you've got the overlay of being LGBTQ on top of that, that means that we really have to be focusing on institutional change, really focusing on what do we have to do to reframe, or to educate our institutions, to change the perspective of our institutions. The effects of the last 3 weeks of what's been happening, these really heartbreaking deaths of Black Americans at the hands of police, I think make us really understand how much systemic institutional change is needed for Black people, for members of communities of color, and also for LGBTQ people. And when you've got those intersecting identities, you know, members of our community are really at the, you know, really poor, you know, don't fare well. And we really, if we're going to basically achieve full lived equality for all LGBTQ people, we need to be looking at all of these components. We need to be looking at institutional change. We need to be looking at ending systemic racism. We need to be ending sexism. We need to basically be treating immigrants fairly, and we need to be focused on people living with HIV and others. You know, we've got a lot of work ahead. I know that our friends at Lambda and NCLR and ACLU are going to take this case and really use it in a way that's, I think, is going to continue moving the needle in terms of achieving additional federal civil rights protections and protections at the states. But we also have to be focused on, you know, both passing laws and education programs that really are changing institutions that LGBTQ people interact with in their everyday lives.
Valerie, can I just jump in there? Because Rick, that was so beautiful.
Absolutely.
Yeah, and it's making me want to say something, which is, yeah, I mean, today's decision was so important, but we've got to look at the full spectrum of issues that affect our community. And, you know, I really want to give a shout out to some of the leaders and activists and advocates in our community, LGBTQ activists of color primarily, who have been fighting some of the hardest fights that we have and have been doing that for decades. And, you know, I'm thinking tonight and today a lot about Dee Farmer, who's a Black transgender woman. You know, I've heard some people say, oh, that Amy Stevens was the first transgender plaintiff to appear before the Supreme Court. No, Dee Farmer was the first transgender plaintiff to appear before the Supreme Court in 1994. Dee had a case about whether or not prison officials have a duty to protect transgender women against sexual violence and assault in prisons. And she started off as a pro se litigant in that case, and she took it all the way up to the Supreme Court, and they ruled in her favor and said, yeah, there is a duty. Prison officials do have that duty. But we are still fighting the levels of violence and assault and harassment of transgender women who are incarcerated. Is still such a horrible, crushing problem. And it's still a battle that we're still fighting, and as well as the battle to get health care, access to health care for incarcerated transgender people. And, you know, there's the cases, we have a case on behalf of this Native American woman, transgender woman incarcerated in Idaho, was denied health care, and her case has gone all the way up to the Ninth Circuit, and the state of Idaho is trying to get the Supreme Court to take that case. But there's issues that go really to the heart of just like basic safety and basic access to urgently medically needed care that we have not even begun to put a dent into. So I'm just saying that by way of saying, I really echo everything you said, Rick, and I really appreciate how Equality California has been so good and so consistent about calling out those issues and not giving up the fight on all of those issues. Really thank you all for that.
Thank you.
I wonder if I could add some related thoughts to this. I think it's certainly true that many people didn't expect Justice Gorsuch to write an opinion of this sort. At the same time, his record before he joined the Supreme Court was one of giving really extraordinary favor to religion claims. And so among the things we have ahead of us, some of which are really particularly important for members of our community who are most vulnerable, are whether faith-based organizations, including those that receive federal money to serve our most vulnerable community members, will have a religious freedom to discriminate when they provide those services, whether it's homeless services or medical care or foster and adoptive services or violence prevention services, or you name it. I mean, our society relies very heavily on faith-based agencies to provide care for people who need care, and many of them do an incredibly dedicated, loving, generous, excellent, professionally excellent job. And some claim a right to provide those services in a way that discriminates. And that can just compound the injury, the dignitary harm, the rejection that can affect any of our members of our communities, and certainly young people especially, and folks who are already living on the margins and surviving harm and poverty and violence. So I think it's right to say, I mean, Shannon, you were being gracious in saying, maybe should we have some concern? I will say we absolutely should have our eyes wide open, be alert, because there are cases pending before the Supreme Court, which will be decided any day now, that will answer or are likely to answer some of those religion questions about how broad is the so-called ministerial exception for workers who are employed by a faith-based agency, who can be considered a minister, how much or how little religious duties can you have and still be deemed exempt from civil rights protections. And there's another case about how this Religious Freedom Restoration Act statute should be understood as a reason, as a legal claim that employers can have for using religion as a reason to discriminate against workers. So we have important issues that we will be getting some answers to quite soon, and there will be more to come. And as we want to focus on the people in our communities who most need our help and most need secure protections that change the conditions in which services are delivered and all of us can live, we have quite a few important legal questions ahead of us, and we should be aware that some of the conservative members of the court may have given something important today. Some of it may be taken away with the other hand, with another legal reasoning quite soon. We need to be alert about that and engage in all the education and organizing and societal change that is the most effective way to really achieve permanent change, to make sure everyone is treated fairly.
I think that's absolutely right. And I also just want to flag in connection to that, the distinction between two sorts of religious freedom rulings the court could make, right? One has to do with the statute that we've mentioned, the Religious Freedom Restoration Act, that sometimes gives religious exemptions from laws that otherwise apply to people generally. That's a matter of statute. That's something Congress can change if the court gives an overly deferential interpretation that gives religious discrimination too much shield or protection. And that's something, for example, that a carefully written Equality Act in Congress could take care not to let that happen. But the so-called ministerial exception that Jenny referred to, the court has said is commanded by the Constitution. And it is an exemption then from statutory rights of all sorts that people might otherwise enjoy when you count as an employee who is a quote unquote minister, whose boundaries are vague and nebulous, and we'll see what kind of clarification we get. As a constitutional ruling, that's not something that can be changed by statute. That's something that could only be changed by the court, short of a constitutional amendment, which is very difficult in the US system. And so it very much matters what the composition of the court is, and the future composition of that is going to be shaped by the president who nominates and the Senate who confirms justices to the Supreme Court. Even completely setting aside the question of whether or not Congress might choose by statute to increase the size of the Supreme Court in reference to the shameless justice grabbing that the Republicans have engaged in.
Thank you. This is an amazing discussion. I think we have time really for one more question. And really that goes to something that David surfaced earlier, and it has to do with states' rights. And I think that you said even in the South that change is happening. Would you say that that today's ruling mean that LGBTQ people who live in low equality states, not like California and Nevada, but the low equality states, as you said, in the South, maybe the Midwest, with no legal protections now, are safe from employment discrimination?
I would say they are safer than they were before the Supreme Court clarified that what so many of us have argued the statute means. It really does mean. It means what it says. But again, Title VII of the Civil Rights Act has its limitations in coverage in scope, and that's only one type of statute in one domain of life, employment, a vital domain, but only one. We interact everywhere, right? The limitless transactions that make up daily life that the Supreme Court has referred to are mostly not covered by the statute that the court was interpreting today. So while it gives us a lot of ammunition in other areas of life, it does not immediately secure protections for people that need to be thought about, and that may well need very different sorts of laws, as Rick was suggesting, to change the institutions, to change conditions so that people can rely on the rights, can rely on attitudes to protect their rights, even if sort of legal representation is beyond their means.
Oh, sorry.
Valerie, I think you're.
I realized I had muted myself. I was just thanking everyone for your brilliant comments and for really bringing us together, telling us who's covered, who's been left out, what challenges lie ahead. All of you have been remarkable. We really thank you so much on behalf of Equality California, Shannon Mintner with National Center for Lesbian Rights, Jenny Pizer from Landwell Legal, Professor Cruz from USC, and Rick Zaber from Equality California. Thank you so much for your comments today. We really appreciate everyone who's participated in our discussion, and we look forward to future conversations. Thank you so much.